Sosa, and on behalf of the Board of Student Advisors and Dean Clark, I welcome you to the final round of the 83rd Annual Ames Moot Court Competition. Tonight, the United States Supreme Court will hear arguments in Bottomless Beer Company versus Rosebud Sioux Tribal Court et al. The case involves issues of personal jurisdiction in the context of Indian law and treaties. The record was written by Professor Joseph Singer and Jessica Herrera, class of 1995. Representing the petitioner is the John Marshall team, composed of Nicola Jurich, Melissa Hart, Jonathan Unger, and Christian Vergonis. Oralists for the petitioner are Anthony Ryan and Roger Catanakis. Representing the respondents is the Felix S. Cohen team, composed of Paul Haig, Jennifer Hooper, Peter Kozinitz, and Amy Weaver. Oralists for the respondents are David Campbell and Jonathan Malice. Presiding tonight as Chief Justice is the Honorable Ruth Bader Ginsburg of the United States Supreme Court. Joining her are the Honorable Sam J. Ervin III, Chief Judge of the United States Court of Appeals for the Fourth Circuit, and the Honorable Diarmuid F. O'Scanlan of the United States Court of Appeals for the Ninth Circuit. Please hold your applause until all oralists finish, remembering that the petitioner has reserved time for rebuttal. Please also refrain from flash photography during the argument. However, the judges will pose behind the bench for a few moments before the argument begins for photos. Best of luck to both teams and enjoy the argument. Thank you.
Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated, please. You going to call the case? Would you call the case? We will now hear from petitioners in the case of Bottomless Beer Company against Rosebud Sioux Tribal Court. Good evening, counsel.
Chief Justice Ginsburg, and may it please the court. My name is Anthony Ryan, and I am arguing here today on behalf of the Bottomless Beer Company. This case concerns the question of whether an Indian tribal court violates due process of law by subjecting to personal jurisdiction a non-Indian corporation for its entirely off-reservation conduct. I will talk about why the basic requirements of due process have not been met here in this case. And my co-counsel, Roger Capriotti, is then going to talk about why no traditional notions of fair play and substantial justice can serve to lower the minimum context threshold required for personal jurisdiction. This case began as an action brought by the heirs of the 19th century Indian chieftain.
What is the standard of review in this matter?
The standard of review is de novo of the findings of law by the federal district court. We brought this suit at first in the federal district court, which enjoined the judgment of the tribal court for having acted without lawful personal jurisdiction over us.
There's a question about the prematurity of your case, is there not?
Yes,
You
Your Honor.
have not been deprived of any property at this point. your complaint in the district court is that the rendition of the judgment of the tribal courts deprived you of property without due process. That's your essential claim?
Yes, Your Honor. Or liberty as well. We were forced to.
But where is the deprivation until the judgment is enforced against you? The mere existence of the judgment doesn't deprive you of anything, does it?
I believe so, Your Honor. The fact that we were forced to go into this forum and to litigate our case when the forum lacked any personal jurisdiction over us is a burden that we've had to face, that we...
Has any attempt been made to levy on any property of the company at this stage?
Not yet, Your Honor, no.
Well, don't we have a problem?
I don't believe so. It seems to me as though the fact that the Indian Tribal Court exceeded the bounds of its lawful limits of jurisdiction and has hailed us in to answer to a court that has no power properly to hear a case against us.
But you
is a
chose
violation.
to enter that forum. You were not required to do that. And until the judgment is enforced against you, what deprivation other than one you inflicted on yourself have you suffered?
Well, the plaintiffs in the tribal court action can now bring other actions in state courts around the country. Our beer is sold in 40 states of the Union, and there are at least 2 states in the country that give full faith and credit to judgments of tribal courts. Most states give comity.
They haven't done any of that yet.
Not yet, Your Honor, no. But the fact that here is our one chance to forestall this piecemeal process of being forced to answer to possibly 40 state courts, and for a federal court to say that the Indian Tribal Court, being a court of limited sovereignty, has overstepped its bounds and did not properly have the power to enter that judgment. That is a federal question which confers federal question jurisdiction upon this court here today under
But
section...
if you successfully defend the first suit that's brought to enforce the judgment, won't you have all the relief to which you're entitled?
We would still perhaps be faced with further suits in other states, Your Honor. And the fact that we have...
No full faith and credit to a judgment if you're right on the merits. No full faith and credit to a judgment of a state court that says we won't enforce this judgment because it was rendered without due process?
That is true, Your Honor. It's a Baldwin case that indeed held so. But the fact that a tribal court has issued this declaration as to the legal rights of this case and has purported to enjoin our sales of beer throughout the whole country puts us in an unfortunate corner where we now cannot choose where we might be
Counsel, I
subjected.
thought that what was rendered against you was a declaratory judgment. I didn't think there was an injunction, was there?
I believe that both orders were issued by the tribal court, Your Honor, and that we were enjoined from any sale of our beer off the reservation by the Rosebud Sioux tribal court. The proper time for the federal court to hear our claim is after an action that we brought in the federal district court, as in the Crow Tribe case that this court heard in 1985, where the question of whether an Indian tribal court had exceeded its lawful jurisdictional limits was held to be a proper case to be judged over at that time, after the person bringing the claim in federal court had exhausted all of his remedies in tribal court. We have litigated through the whole tribal court process at 2 court levels. We have exhausted all of our remedies and have no other recourse to have this matter settled now other than to bring our cause of action in federal court. The 2 reasons why the tribal court lacked personal jurisdiction over us are first that the long-arm statute used to draw us in to the courts of the forum state was passed without the Rosebud Sioux tribes having proper legislative jurisdiction. Once this long-arm statute is struck down, as applied to us, the Rosebud Sioux tribe lacks any further basis for hearing this case. Indian courts are courts of limited sovereignty, and tribes may only enact statutes that regulate the conduct of non-members of the tribe in very limited circumstances, none of which is
Didn't
applicable.
this statute that you're raising, didn't it say to the extent consistent with due process?
Yes, Your Honor. The problem of the statute is not a facial challenge to the statute, but rather the statute as applied to us, as applied to a non-member of the tribe. The tribe lacked...
Then you're changing your, I thought in the brief you were making a facial challenge to the statute.
No, Your Honor. The statute would be valid, say, if a member of the tribe had moved off tribal lands and were living in a state of the Union somewhere and were being brought into tribal court. We, however, are non-members of the tribe, and since we have not entered into any contracts or other dealings with the tribe or members of the tribe, and since we have not engaged in any conduct upon tribal lands.
Then you're modifying what you asked in the brief to have the statute struck down. You said...
As applied to us, Your Honor. Our language may have been
Well,
unclear.
you do have a subsidiary that is doing business on the reservation and with the tribe, do you not?
Yes, Your Honor, we do.
What responsibility do you have for them?
None, Your Honor. This court has held, ever since the Cannon case in 1925, that if corporate formalities are adhered to, the conduct of a parent corporation and of a sub cannot be linked and must be kept separate. The burden is on the estate of Crazy Horse to plead particularly certain facts which might show that we completely dominate that company which sells Western-style clothing and not be a...
Speaking of burdens, who has the burden of establishing that the tribal court lacked personal jurisdiction in this matter?
They have the burden of showing that the tribal court had personal jurisdiction over us. The plaintiff must plead certain facts that show that the tribal court was right in having entered this judgment against us and had the requisite personal jurisdiction over us.
Now, you indicated earlier that with respect to the standard of review, that it's strictly a question de novo, but I gather that your opponents disagree and they have a different view. What's your response?
Well, they do make an argument that the burden lies differently. They have no cites in that section of their brief, but rather make an argument relying upon doctrines of comity, full faith, and credit, which they even concede in a footnote are not applicable here. This court, in the Crow tribe case, did not reach the question of what the burden was. However, the two circuit courts that have heard this question have ruled that the burden is, on legal matters, a new judgment by the court, and indeed in questions of law, that is the sort of general rule, and it should also apply here today, given that it is a federal jurisdictional statute that we are looking at for whether this question arises under federal law, for whether the tribal court has exceeded the limits of its lawful powers, so that a federal court can review that de novo.
I'm not clear on whether you're attacking this statute as having some infirmity in the way it's written, or whether you're just saying this is a perfectly fine statute, it just doesn't apply to our case. Which of those two positions are you taking?
It's much more like the latter position, Your Honor.
Didn't sound that way in your brief. The statute speaks of within the reservation, torts committed within the reservation, property or acts within the reservation. And yet you ask us to strike down, those are strong words, strike down the statute as without legislative jurisdiction. And now you're modifying that, I take it.
Indeed, Your Honor. Only as applied to a non-member of the tribe does the tribe lack the legislative jurisdiction to pass this statute. We cannot challenge matters of tribal law and the tribal court's application of our conduct to the legal standards set forth in their long-arm statute. But
Suppose someone comes onto reservation and commits mayhem, but that person is a non-Indian. The statute, by its terms, would reach such a person.
Yes, Your Honor.
So the statute does cover some non-Indians.
Indeed, Your Honor. In the two limited categories of a non-member of the tribe who has voluntarily entered into dealings with the tribe or members of the tribe, and secondly, with a non-member of the tribe who enters onto tribal lands and engages in conduct
Is
there.
that
out of which,
limited to a physical entry?
yes, Your Honor. In the Montana case, and again in the Borland case, this court clearly held that the conduct must take place on tribal lands, not the impact of the conduct, but rather the conduct must take place on tribal lands, since the court in that case dealt with the case of a non-member of the tribe whose conduct had been on non-Indian-owned fee lands within tribal boundaries, and the impact had been felt on the tribal lands. So
Thank you,
that's-
counsel. I think your time has expired, has it not?
Oh,
Oh, I'm
The-
sorry.
Counsel, could I ask you how you respond to the estate's argument that Montana doesn't apply in this case because, after all, this is a procedural statute?
All statutes that regulate activities of non-members and that attach legal consequences to the conduct of a non-member of the tribe fall under this test. Our conduct is now altered. We can no longer conduct our business with a minimum assurance of where we might be liable to suit. If we can be sued in the tribal court forum without
You're
having
peddling
entered.
beer in 40 states. Doesn't that
Yes, Your Honor.
give you a lot of area in which you can be sued?
Indeed it does, Your Honor, and we'd be happy to.
Be sued in all 40, but not.
That's right. Any of the 40, state or federal court. The second fundamental reason I just wanted to quickly add why there is no due process here is that we have no minimum contact, and that we have in no way purposefully invoked the benefits of Rosebud Sioux law because we do not sell our beer on the reservation.
Why isn't the Calder case just a model for this one, where people act outside and cause injury inside? Why
Well-
should the tribes have any less authority to call people to account in their courts than California does?
Tribes have equal power, indeed. However, in the Calder case was about an intentionally libelous story where the writers had purposefully directed and expressly aimed their conduct at the forum state, where they knew that because their newspaper was circulated there.
But isn't
It
that
was-
exactly what the estate is alleging here, that you knew exactly about Crazy Horse, you knew about the symbols, yet you appropriated them on the beer label? Isn't the analogy quite the same?
I don't believe so, Your Honor. The mere unilateral sending of the letter, as this court held in Hansen, the mere unilateral contact of the plaintiff to the forum state or of the plaintiff to us cannot serve to manufacture minimum contact between us and the Rosebud Sioux Tribal Forum. We rather would have had to have purposely availed ourselves of the forum.
Well, you purposely took Crazy Horse's name and you purposely took symbols belonging to the Sioux Indians, didn't you?
Indeed, Your Honor. We had no intent, however, through that conduct to reach this particular tribal forum.
Nobody
nor to
ever
injure.
intends to injure anybody, and that's why we have lawsuits. Is intent going to be the test?
Yes, Your Honor. Conduct that is purposefully directed. Calder deals only with a very limited category of cases. Those, for instance, intentional libel cases, where the conduct is purposely directed and expressly aimed. Fact showings that we simply do not have here. We did not manufacture our beer and put a certain name on our beer so as to cause injury or so as to cause an impact on the Rosebud Sioux lands, knowing that our beer would then be sold there. Rather, we've taken all measures that our beer is not sold
So
there.
ignorance is a defense.
Indeed, Your Honor. In Volkswagen against Woodson, the automobile dealer in New York State did not know that his customer would drive the car across the whole country to Oklahoma, and ignorance was a defense. It was not reasonable, foreseeable, for us to believe that we would be hailed into court in this form.
Mr. Ryan, now I believe your time is up, and we thank you for your
Thank you, Your Honor.
argument. And now we'll hear from Mr. Capriotti.
May it please the Court, my name is Roger Capriotti, and I also represent the petitioner in this case. I will argue that in the absence of minimum contacts, that traditional notions of fair play and substantial justice cannot be used to justify a finding of jurisdiction in this case. Traditionally, the analysis ends, personal jurisdiction analysis ends with the inquiry into minimum contacts once the court has determined that whether they exist. In this case, respondents bear a heavy burden in demonstrating to you that reasonableness factors and other policy concerns justify a finding of jurisdiction without minimum contacts. Before I move on to the bulk of my time, which will be based discussing much of the lower argument, the argument of the lower court and of respondents in their brief concerning the treaties and alternate fora, I'd like to first establish several factors that weigh in favor of a finding on unreasonableness, in this case, if a jurisdiction is asserted, that actually help to counter the arguments that respondents bring up. First, the defendant in this case, the petitioner, has a severe difficulty in being forced to litigate in a foreign legal system, akin to what this court has described in Asahi. Traditional mechanisms by which this burden can be alleviated are unavailable to us, Your Honors, because of the unique nature of the tribal court that it lies outside both federal and state systems.
More than hearing a claim that arises under the law of Saudi Arabia, for example?
Probably not, Your Honor, but in essence very similar, because since it lies in the Rosebud Sioux Tribal Court and is akin, as Chief Justice Marshall once said, these reservations are domestic dependent nations. The issue here is that something like removal, which would allow us to remove from, say, a state court to a federal court to get us away from the state procedures and get to federal procedures, which we may be more familiar with, is unavailable to us, as it would be unavailable in the case you put an example of.
Well, now, wait a minute. You have a subsidiary on the reservation. Certainly, they must have some familiarity with Indian law.
Yes, Your Honor. We do have a subsidiary on the reservation. However, as petitioners argued in their first brief, for the same reasons that we are not subject to general jurisdiction because of the actions of our subsidiary, you can't impute constructive knowledge of the laws of the Rosebud Sioux to a subsidiary.
Yeah, but we're in a reasonable test discussion at this point. The rules are not quite as talismanic, are they?
Yes, Your Honor, you're absolutely correct. What I would say then is fairly simple, that it would be up to respondents to allege or to show to you that we had some sort of exclusive control over our subsidiary and that might actually have some more constructive knowledge.
I wonder if the reasonable test doesn't tilt possibly toward the estate, because they say they've got no other place they can bring this action.
That, however, Your Honor, is not the case. Respondents base their argument that there is no alternative forum in this case on two issues, on the infringement test and on Public Law 280. Now, under the infringement test set up by this court in Williams v. Lee in 1959, if it's an infringement on tribal sovereignty, then the state action is barred. What petitioners have argued is that the state in this case has an avenue in which to seek a remedy in this case. We've mentioned how we sell our product in about 40 states of the Union, and after a proper minimum contacts analysis.
Would tribal law apply in any other forum in the land other than this one?
Your Honor, it is entirely possible. what would happen is, in the state court or federal court, they would apply the choice of law provisions of that forum. One of the reasons we find that...
You have said it's entirely possible. You have conceded then that tribal law might be chosen by another forum. Is that correct?
Yes. Yes, I mean...
Then tell me how you can possibly square your argument with International Sioux, that great path-breaking case. Didn't Justice Black say, if the state can apply its law, if it can tax, then of course it has jurisdiction to apply that law to the people whom it can tax? Here, if it's a proper law to govern the conduct of these people, then a fortiori mustn't the courts that have the proper law have authority to apply their very own law, rather than have some foreign tribunal apply that law?
Not necessarily, Your Honor. International Sioux, of course, developed the minimum context analysis, and was what my co-counsel and I are arguing does not, that there are no minimum context.
I'm calling your attention to an argument by one of the justices that that was all beside the point. This highfalutin language about minimum context. The state had a tax. It had a law to apply, and its courts had jurisdiction to apply that law. If you are conceding that the tribal law could govern the conduct of bottomless beer, then mustn't the tribe have authority to apply that law?
Not necessarily the case. For instance, in our brief, we discuss Maryland as one of the states in which the state could possibly bring suit, where we have a brewery, so minimum context would probably exist. In that situation, the choice of law provisions for Maryland are under lex loci delicti, which would, in essence, apply the law of where the tortious conduct or the impact would have taken place. So if the state came to a court in Maryland and asserted that, and obviously there would be jurisdiction in that case because of the minimum context analysis, and asserted that its law should apply because the impact was felt on the reservation, as respondents do argue in their brief, then arguably minimum context would exist, and the tribal court in that case, the estate could get its law.
Then you're suggesting that it takes less in the way of context to have a state's law governed than it takes to have that state exercise personal jurisdiction.
In terms of choice of law provisions and personal jurisdiction, the standards are similar, but one is very different from the other. In the case of Allstate of this court, where it discussed the choice of law provisions and what constitutional requirements there are on these choice of law provisions, this court explained that things that must be taken into account are the contacts between the forum that's trying to assert its own, or the state that's trying to assert its law, and the litigation, and also the interests that are taken into account. So that the choice of law provisions aren't necessarily only about minimum contacts, but rather have to do a lot more with the interests of the different states in the litigation. However, that is not the same analysis, I would argue, as the minimum context analysis under International Sioux. There are several factors, a couple of other factors that weigh in our favor in this case in terms of the balancing. Another one is is concerns of federalism. In the federalism is something that is throughout these concerns of personal jurisdiction. And basically, the issue here is the states must not be able to assert their jurisdiction beyond in a way that would infringe upon the sovereignties of other states. And what petitioners argue is that tribal courts have traditionally been limited to their own confines of their reservation in terms of their assertion of jurisdiction, and continue to be so today. So this is another concern that is quite important in this case and should balance against.
Well, would you address the concern expressed in the state's brief that Public Law 280 would be a bar?
Of course, Your Honor. The Public Law 280 was passed in 1953 by the Congress to facilitate the assimilation of Native Americans into the state and federal systems. It is a jurisdiction enhancing as opposed to a restrictive statute. Respondents are in error when they argue that it preempts a state from asserting jurisdiction, for the fact that this court's decision, or the decisions of this court in the case of the 3 affiliated tribes in 1984 and in 1986 shows that this preemptive effect of Public Law 280 is jurisdiction enhancing. In 3 affiliated tribes in 1984, this court pointed out that it has always been the case that an Indian could bring an action in state court. That dates back to the time of Williams v. Lee in 1959. But furthermore, this meshes with what the public policy behind Public Law 280 was. It was a way of facilitating a jurisdiction, the assertion of jurisdiction by states over the reservations in a way that may not have been otherwise available to them because it could possibly have violated the infringement of the Indians.
Well, what's the authority to justify or to support that argument? Is there much out there?
Well, it's the reasoning that is in the Fort Berthold, the three affiliated tribes cases 1 and 2, about how it talks about that the legislative history and the policy behind Public Law 280 was to facilitate states to assert jurisdiction, not necessarily restrict them from doing so.
But is there any decision that squarely holds that the estate could sue you, for example, in Maryland, which is where you have your factory?
All I would say, Your Honor,
With
is
respect
that
to the 280 issue.
with respect to the 280 issue, there is none on point to fit the facts of this case. But as far back as in Williams v. Lee in 1959, Justice Black clearly said that it was always the case that an Indian could sue in state court. The reason this is fine is because it's not an infringement upon tribal sovereignty, which is the second argument.
But what about your argument, your very lawsuit, and the sovereignty of this tribe? There is a statute that prevents federal courts from enjoining proceedings in state courts. That's a well-known prohibition. Shouldn't a federal court regard a tribal court as a court of equal dignity? And if a federal court can't nullify a proceeding in a state court, then equally, shouldn't a federal court not be permitted to nullify the decision of a tribal court?
Your Honor, it's a little different in this case because it is a tribal court as opposed to a state court. The case law on this points out that these challenges can be brought once defendants have exhausted all tribal remedies, as petitioner has in this case by going through both the district court of the tribal court and the court of appeals within the tribal court system. This collateral attack isn't meant as any disrespect to the tribal court's proceedings or anything like that. The point that I'm trying to make is that it is erroneous to say that infringement, that allowing Indians, in this case, to sue in state courts, the argument that there's no alternative forum because they can't assert this jurisdiction, is wrong in light of the fact that there's no infringement here. The tribes have no interest in protecting non-Indians. And what we're saying is that there are alternative fora out there simply because Indians do have this opportunity to sue in these courts.
Well, one thing that's bothered me about this case is that one of the parties on the estate side is the tribe itself. Presumably, the tribe itself is immune to suit, is it not, as a sovereignty, as a sovereign?
No, it is not, Your Honor. The issue in this case, we are discussing not sovereign immunity, but official immunity in this case. We are asserting that the members...
Well, I realize that's your argument, but what is the practical difference? Is there any significant difference between the two?
Yes, the difference is that we are arguing that the tribal court overstretched its jurisdiction in finding that it could do this, that there was a finding of minimum context and so forth. So that's why it's about official immunity in that instance. The issues of sovereign immunity that develop in this case arise from the fact that the lower courts and the respondents have argued that there are no alternative fora available here. And for instance, the case that respondents rely upon is a Ninth Circuit opinion by R.J. Williams, the R.J. Williams case, that is directly inapposite to this case, where...
Those Ninth Circuit opinions aren't always that reliable, you know.
Counsel, do I understand your argument to be that if respondent is right, that there is no other court that would entertain a claim under tribal law, then there would be the plus factors that even if there weren't the necessary minimum context for ordinary cases, then this would be a proper forum. So we have to resolve whether any other court would entertain a claim under tribal law.
We argue that Yes, Your Honor. We argue that there is no alternative form, that there is an alternative form
But if
available.
you're wrong about that.
Yes.
Then then the requisite personal jurisdiction nexus is satisfied, because we have that plus factor.
No, it would not be enough to overcome the minimum contacts for the reason that, first, you'd have to assume that they had this guarantee to this publicity right that respondents agree, which of course would mean that you'd have to agree with their interpretation of the treaty that it guarantees this right. Second of all, you would also have to have found, you would also have to disagree with us in our statement that when Congress passed the ICRA in 1868, what it was doing, it was using its plenary powers to restrict both the sovereignty of the tribes, in this case, in asserting jurisdiction, and
Counsel, would you conclude your sentence,
Sure.
because I think your time is up.
and that it would also be a restriction on the treaties. So, thank you.
Thank you, Mr. Capriotti. We'll now hear from respondents, and Mr. Campbell will speak first. Mr. Campbell, please proceed.
Chief Justice Ginsburg, and may it please the Court. My name is David Campbell, and with co-counsel Jonathan Malice, I represent the Rosebud Sioux tribe, the Tribal Court and Tribal Court of Appeals, and the estate of Tasunke Witko, known as Crazy Horse in English. This case concerns the ability of Tasunke Witko's heirs to protect their spiritual and personal rights in Crazy Horse's name from the degrading commercial exploitation by the Bottomless Beer Company. I will argue first that the district court did not have subject matter jurisdiction over petitioner's claim. Second, even if this case was properly before the court, I will argue that the beer company had sufficient minimum contacts with the reservation to satisfy due process. Finally, co-counsel will argue that traditional notions of fair play and substantial justice warrant the tribal court's exercise of personal jurisdiction over petitioner.
Would you clarify, before you get into your main part of your argument, this standard of review issue? There seems to be some discrepancy.
Yes, Your Honor. We would argue first that the district court didn't have subject matter jurisdiction over this claim. If this court determines that the district court did have subject matter jurisdiction, then the standard of review should be one that places the burden on petitioner in this case, as the lower court did in Judge Story's opinion by saying that the burden should be on the party seeking a finding that a tribal court exceeded its personal jurisdiction. This is properly the case in light of the congressional decision in
What
past.
authority do you cite in support of that argument?
Your Honor, only the authority of the lower court opinion. The only two federal courts which have ruled on a relevant matter held that a tribal court's subject matter jurisdiction is subject to a de novo standard. However, the personal jurisdiction of a tribal court, which relates to the ICRA standard, the standard of review for reviewing personal jurisdiction has never been determined by a federal court. In light of the particular considerations of the ICRA, the burden should be placed on a party seeking affirmative.
What would that burden be? How would you state the burden?
Your Honor, as the lower court framed it, it should be a finding that the tribal court acted in an arbitrary manner or in a fundamentally unfair manner. In this case, the tribal court clearly did not do so, and we would argue that
Mr. Campbell, I thought we were arguing here just questions of law, that the facts, the relevant facts to determine jurisdiction are not in dispute. So we're not talking about burden of proving facts. We're talking about the applicable law.
Yes, Your Honor, we are. We would first.
So why are we talking in terms of standard of review at all? It's a legal question, right? The facts that for current purposes are not in dispute.
That's correct, Your Honor. The reason why we argue that the burden should be placed on petitioners, first, that the ICRA claims are not ones that can be brought in a federal forum other than through habeas corpus actions. If this court...
Well, why is this an ICR claim? And nobody is in custody, which is what is involved with habeas.
It's an ICRA claim, Your Honor, because what petitioners claimed is that the tribal court violated its due process rights. The Constitution of the United States does not apply...
They put due process in the context of the ICRA, but we have detained you from making your principal subject matter jurisdiction argument, so please proceed with that argument.
Yes. As this court recognized in Santa Clara Pueblo, affirmative causes of action alleging ICRA violations by tribal courts cannot be heard in federal court, even in cases seeking injunctive or declaratory relief. This court's opinion reflected the fact that Congress, in passing the ICRA, made the deliberate choice that tribal courts be the appropriate forum for hearing ICRA claims.
Mr. Campbell, let me just stop you there and suppose that this lawsuit had not been brought in federal district court and that you are, that there's an endeavor to enforce the tribal court judgment against Bottomless beer
Yes, Your Honor.
in a state court. The defense would be they could not assert authority over us. There would be no question of subject matter jurisdiction for that kind of case, would there?
That's correct, Your Honor.
Why isn't this just that case turned upside down?
Because, Your Honor, in this case, petitioner is asserting an affirmative cause of action that a federal court can review preemptively a tribal court's assertion of personal jurisdiction. If the estate seeks enforcement of the tribal court order within a state or federal court, then that court can review it under full faith and credit or comity principles, as the vast majority of states do. A state reviewing a tribal court order under comity principles can appropriately review whether that court has followed its own rules before the reviewing court can decide whether to apply that order. In this case, petitioner has alleged a federal question grounded in the ICRA, and because federal courts are those of limited jurisdiction, as this court found in Santa Clara Pueblo, this court does not have subject matter jurisdiction over the underlying action because Congress, in passing the ICRA—
And the defense to the enforcement action wouldn't be a federal question?
Your Honor,
If the defense is this judgment was rendered without due process, isn't that a federal question?
Yes, Your Honor, it would be a federal question which could properly be asserted within the state forum. In this case, the federal question itself is asserted as the basis of the federal court's jurisdiction. In the hypothetical that you've posed, the estate would be bringing the action in the state or federal court, seeking enforcement. Like in any other case where a foreign court's judgment or another state's judgment is brought, the reviewing court can determine whether the rendering court properly had personal jurisdiction over the underlying action.
What do you do with what this court said in 3 affiliated tribes in this area?
Your Honor, in this particular context, because they're asserting a cause of action under the statute, 3 affiliated tribes is inapposite. In this context, they're asserting a cause of action in an area in which Congress has directly spoken. As this court recognized in Santa Clara Pueblo, the causes of action in federal court can only be brought through habeas corpus remedies. And in that sense, 3 affiliated tribes is not on point. For the same reasons, Your Honor, the sovereign immunity of the tribe precludes the federal court's subject matter jurisdiction in this case.
That was a puzzling argument to me about the United States itself would not be immune, I take it, from an action seeking injunctive relief, would it?
Your Honor, if that cause of action were brought against a government official, it would not be immune. Yes, that's the case.
The United States.
I believe so, Your Honor. So,
The United States would be immune?
if the suit were brought against the United States itself, yes, Your Honor, unless Congress
Has
had.
sovereign immunity from claims for injunctive relief, for non-monetary relief? There's no monetary relief sought here, is that right?
That's correct, Your Honor. Yes, if the action is not brought against an official itself, then the
Well, if I tell you, and I'm reasonably confident of this, that the United States does not have sovereign immunity from claims for equitable relief, for non-monetary relief, why should the tribe have greater immunity than the United States does itself?
Your Honor, that was this court's explicit holding in Santa Clara Pueblo, that a tribe, even in an action seeking injunctive or declaratory relief, has sovereign immunity from that underlying action if the action is brought against the tribe itself. That holding in Santa Clara Pueblo has subsequently been applied in numerous contexts where the action is for equitable relief. If the action here were brought against the tribal judges, either by name or by title, then the action would appropriately be heard within this forum. However, because it's brought against the tribe itself and tribal entities, it's barred, as reflected in this court's holding in Santa Clara Pueblo.
Apart from other arguments, petitioner said it was a mere misnomer. We were just meant to sue officials for injunctive relief, which since ex parte Young, everyone knows can be done.
Yes, Your Honor. In this particular context, Your Honor, the rules cited by petitioner are not on point. Federal Rule of Procedure 25 and Supreme Court Rule 35 indicate that if an official is named, either by title or by name, then if that official is succeeded by another one, then the mere defect in the name will not bar the suit. In this case, however, petitioner is seeking to effectively add a new party at the Supreme Court level. It never added that party at the trial level. It didn't provide notice to that party. It can't effectively assert that claim, certainly not under Rules 25.
What application does this aspect of your argument have to the estate itself?
The estate itself, Your Honor, as petitioners recognized in their brief, cannot be the subject of this cause of action in the sense that affirmative causes of relief under the ICRA are not brought against private parties, like the estate in this context. Petitioners asserted they joined the estate as an interested party, but not as a party against which the underlying cause of action was asserted. Even if this court determines that the district court had subject matter jurisdiction, the assertion of jurisdiction by the tribal court was consistent with due process
Would you
standards.
review that concession again, because wouldn't the relief be fully effective if the estate can't enforce the claim, couldn't enforce the judgment?
The relief in that sense would be fully effective, Your Honor. I mean, if we're asserting that if this court determines it can hear the action,
Yeah.
then the underlying merits of petitioner's claim weigh in our favor, that the finding of personal jurisdiction by the tribal court was consistent with due process, as the Circuit Court of Appeals found. This assertion of personal jurisdiction by the tribal court was validly made under the terms of its long-arm statute. The Tribal Court of Appeals held that by causing tortious injury within the forum, the beer company subjected itself to service of process and thereby fell within the terms of the long-arm statute. Now, this long-arm statute its application must be analyzed under due process standards, as is reflected in the terms of the statute itself. It's enacted with respect to due process standards. But in this case, under the effects test, as articulated in Calder, the assertion of personal jurisdiction comports with due process analysis. The effects test emphasizes that where a party takes intentional actions, like the beer company here, in intentionally appropriating Crazy Horse's name, and affiliates itself with the forum, in this case, the beer company by using Sioux religious images like the medicine wheel and the ceremonial pipe, then if it knowingly causes injury within the forum, it is properly said to be subject to jurisdiction, personal jurisdiction, within that forum. Under the effects test as articulated by this court in Calder and applied in subsequent cases, like in Hugel v. McNell in the First Circuit, the tribal court's assertion of jurisdiction satisfied.
But aren't you pushing Calder to its outer limits? Has there ever been a case which held that there was jurisdiction where the defendant had absolutely no contact whatsoever?
Yes, Your Honor. For example, in the case of Lex Computer Management, in that case, the defendant corporation, which was located outside of New Hampshire, sent allegedly intentionally defamatory letters to out-of-state customers and prospective customers of the New Hampshire plaintiff. In that case, the court found that the exercise of jurisdiction was proper under Calder, even in the absence of any direct contacts between the defendant and New Hampshire.
But in Calder, there were a lot of inquirers sold within the state of California, were there not?
Yes, Your
And here
Honor.
there's no bottomless beer sold on the reservation.
That's correct, Your Honor. In Calder itself, however, the court did not impute the context of the inquirer, which was the employer of the defendant, editor, and author, to the defendants themselves. Instead, the circulation of the inquirer within California reflected the knowledge that they had that any potential injury from their action would be felt within California. In this particular case, there doesn't need to be any imputed knowledge of injury being caused within the forum. In this case, the beer company had actual knowledge of the extent of the injury they were causing through the degrading association of Crazy Horse's name with the liquor and to the unconsented use of his name for commercial profit. In Hugel v. McNell, the First Circuit recognized that even in the absence of direct contacts, knowingly causing tortious injury within a forum where an actor acts intentionally satisfies the purposeful direction requirement and constitutes a purposeful contact under due process standards. In the same way, the assertion of personal jurisdiction in this case satisfied those standards. The injury to the tribe, to the estate, was felt within the forum, both the injury in the sense of the degrading association of Crazy Horse's name, the invasion of the privacy right of the estate, and the injury to the right of publicity, the underlying right to control the use of Crazy Horse's name for commercial profit. As in the case of Sinatra, where the injury to that right of publicity was felt where Sinatra lived in California. In this case, the estate felt that injury within the tribal forum.
But if you're imputing knowledge to bottomless beer, this is a rather strange right that's being asserted, a right over a century after the death of this chief. So is it likely that Bottomless Beer or its attorneys would even be aware that anyone would have a right of publicity in the name of someone who died over a century ago?
It's possible, Your Honor, that the beer company would not know that there would be an individual who might assert a right. In this case, however, there was actual knowledge of the injury that was being inflicted through the letter delivered by Sam Redbird himself, who was the plaintiff administrator in the underlying case in the tribal action. In this case,
So prior to the sending of the letter, there was no knowledge, and after the sending of the letter, there was knowledge?
Your Honor, this court could impute knowledge of the harm being caused by the action, as several courts have done in analogous circumstances. Possibly given the uniqueness of this cause of action that's being asserted.
Give me a for instance.
Your Honor, in the case of Koblenz, the defendant was a Swedish corporation which engaged in contractual relations with General Motors. The court found that where an Alabama truck dealer, which had been in a contractual relationship with GM, brought an action in Alabama, the Swedish corporation, because when it engaged in its dealings with General Motors, should have known of the injury that it might cause to the contracts of GM with these other forums. The finding of knowledge was appropriate, that it could be imputed in that particular case. In the same way, in the VDI case, the court found that by sending out-of-state letters, defamatory letters about the New Hampshire corporation, the defendant in that case could be charged with knowledge that the harm that would stem from those intentional actions would be felt within New Hampshire.
I'm bothered by the outer limits of the test that you're proposing. Suppose someone is accused in the tribal court and the court engages in some outrageous assertion of jurisdiction. Are you saying that there is no way to have that tested in a federal court?
Your Honor, the assertion of jurisdiction would always be subject to the review of the tribal court's subject matter jurisdiction. In that sense, it could be reviewed. And secondly, if a party within the forum ever tried to seek enforcement of that action in another forum, it would be reviewed to see whether the rendering court had jurisdiction in that case. But again, the underlying limits on the subject matter jurisdiction of tribal courts.
Well, suppose the issue is due process, whether there was due process in the tribal court.
No, Your Honor. Other than through the habeas corpus remedy, there will not be a cause.
Which is a criminal only.
Yes, Your Honor. This principle reflects Congress's intent in passing the ICRA, that because Indian tribes are sovereign nations, dependent, yes, a conquered people, yes, but because they're sovereign peoples, there should be only limited infringement of that sovereignty through creating causes of action in federal court. Therefore, any cause of action under the ICRA, whether a due process cause of action or an equal protection one, like in Santa Clara Pueblo, can't be brought in federal court other than through the habeas corpus remedy. This reflects the sovereignty of the tribal forum and Congress's intent in passing the ICRA. Because the Constitution does not itself apply to the actions of tribal forums, only the ICRA would serve as the only basis for a due process claim in federal court. In sum, Your Honors, this court should order dismissal of the underlying cause of action for lack of subject matter jurisdiction in the district court, or should affirm the circuit court's finding that the tribal court had personal jurisdiction over the beer company in a manner satisfactory with due process standards. Thank you.
Thank you, Mr. Campbell. We'll hear from Mr. Malice. Please proceed, Mr. Malice.
Chief Justice Ginsburg, and may it please the Court. My name is Jonathan Malice, and with co-counsel I also represent respondents. Traditional notions of fair play and substantial justice warrant the tribal court's exercise of jurisdiction in this case. I will argue first that the estate had no other forum available in which to obtain convenient and effective relief. Second, that the tribe had a strong interest in adjudicating this case of first impression under tribal customary law and protecting its residents from harm. And third, that a denial of jurisdiction would breach the Treaty of 1877 with the Sioux Nation. In sum, these reasonableness considerations far outweigh any possible burden on the beer company of litigating this case in the tribal forum. First, Your Honors, petitioners misread Public Law 280 and this court's opinion in 3 affiliated tribes. This court recognized in 3 affiliated tribes that the strict procedures of Public Law 280 must be followed before a state can obtain civil jurisdiction over causes of action arising in Indian country. Because there is no evidence that Ames has followed the procedures of Public Law 280, either the procedures laid out in the initial statute in 1953 or as the statute was amended in 1968, Ames simply cannot be heard to have civil jurisdiction over this cause of action because it arises in Indian country and involves Indian parties.
But the tribe could allow Ames, if it wanted to adjudicate the claim, right?
No, Your Honor.
No?
The tribe could not allow Ames to adjudicate this private claim. The tribe cannot unilaterally provide the state with the subject matter jurisdiction over this claim. Subject matter jurisdiction represents the inherent authority of a court to hear a case. Public Law 280 requires both affirmative legislation by the Ames legislature and tribal consent. I'm speaking now to Public Law 280 as it was amended in 1968. So tribal consent alone would not satisfy the strict procedures of Public Law 280. This court recognized in 3 affiliated tribes that affirmative legislation is necessary because obtaining civil jurisdiction over causes of action in Indian country is both a responsibility and a burden on states, and states must take that affirmative step through their legislative acts in order to obtain such jurisdiction. Therefore, there's a great burden on the estate here because there's no other form available, and that is one of the factors justifying the tribal court's exercise of jurisdiction.
Are you saying that no other court then that this is the only show in town, that
Correct.
the tribal court is the only place where this action can be brought?
That is correct, Your Honor. Because this cause of action arose in Indian country and involves Indian parties, this cause of action can only be brought in the tribal court. Ames does not have jurisdiction over this case.
So then all this that you had in the brief about the difficulty of other courts knowing what the tribal law is, that's all beside the point, because no other court could, no matter how hard it studied tribal law. Is that essentially your point is there is exclusive jurisdiction over this claim, and it is in the tribal court?
That is correct, Your Honor. However, as this court recognized in 3 affiliated tribes, if a state exercised jurisdiction over causes of action arising in Indian country prior to the enactment of Public Law 280 in 1953, that jurisdiction is lawful to the extent that it does not violate the infringement test laid out by this court in Williams v. Lee. Therefore, we argue in the alternative that if this court finds, as the record does not show, but if this court finds or wishes to consider hypothetically that Ames had exercised such jurisdiction prior to 1953, that jurisdiction nevertheless would violate the infringement test, and therefore whatever residual jurisdiction or pre-1953 jurisdiction which may exist in Ames, and we have no evidence to that effect, would not be lawful.
Excuse me, here we have a non-Indian being brought into state court. We don't have the problem of an Indian being brought into a state court. Doesn't that make a difference?
No, it doesn't, Your Honor. As Congress initially enacted Public Law 280 in 1953, it expressly chose the language of cases where there are Indian parties. It did not indicate the distinction that petitioner wishes to draw here between Indian plaintiffs and Indian defendants. Similarly, when Congress amended the statute in 1968, it again chose the language of Indian parties. It did not choose language such as petitioner suggests of Indian plaintiffs versus Indian defendants. So the distinction petitioner wishes to draw here simply has no basis under the plain language of the statute.
But then you are saying that there is only one court that could.
That is correct, Your Honor. And that is
So
the
we
tribal
have
court.
essentially a non-transitory claim, that the tribes, that the estate's claim is non-transitory. There's only one place where it can be brought, an a fortiori, there's personal jurisdiction.
Not a fortiori, Your Honor. If this were a different case and there were no minimum contacts with the forum, or there weren't other reasonableness considerations at play here, perhaps this case could not be brought anywhere. However,
How can a forum apply its law to govern the conduct of a person if there are not minimum contacts with that person? To provide the rule that regulates how that person behaves? You have just suggested to me that there might be a case where the tribe legitimately could apply its law, but it couldn't get its hands on the defendant to hail him into the court.
Your Honor, in a hypothetical case, if there are no minimum contacts, the tribe couldn't apply its law to that defendant, and therefore it also could not exercise personal jurisdiction over the defendant. However, as my co-counsel argued, there are minimum contacts between the beer company and the tribal forum, and these other reasonableness considerations, such as the lack of an alternative forum and the tribe's grave interest in hearing this case, and other interests such as the tribe's interest in upholding treaty rights that it won against the United States.
To find those minimum contacts, to what extent do you look to the subsidiary MMP?
Your Honor, we do not rely for the minimum contacts aspect of
You
personal
don't rely
jurisdiction.
on that at all?
I'm sorry?
I say you don't rely on that at all?
We only look to the subsidiary, Your Honor, for the purpose of rebutting petitioner's assumption that it has no knowledge whatsoever of tribal law, tribal customary law, or Indian reservations. Certainly, by having a subsidiary that sells its product on the reservation, having several subsidiaries, Your Honor,
Well, it sold blue jeans and boots, didn't it?
that's what the record states, Your Honor.
And
That's
it
correct.
doesn't have much knowledge then, I would suggest, of an estate or a state law, would it?
Your Honor, it would have some knowledge, however, of tribal procedure, which is modeled after the Federal Rules of Civil Procedure. It would have knowledge that tribes have tribal customary law that could be applied. The point with the subsidiaries, Your Honor, is simply that the beer company cannot be heard to have no knowledge of tribal law or tribal procedure. This is not a dispositive point. In personal jurisdiction analysis, in the reasonableness prong, all these considerations come into play to support the exercise of jurisdiction or to deny it in a different case. In this case, however, because there was no alternative forum and the tribe had a strong interest in developing and applying its own customary law in a case of first impression, the tribal court's exercise of jurisdiction was reasonable. No other court could properly apply tribal customary law because, as this court recognized in National Farmers, tribal courts are courts best able to interpret tribal customary law.
But isn't that true of every state and its own law? Isn't it true of every foreign nation and its own law? And yet sister states apply each other's law all the time. Courts in the United States apply laws of foreign countries. Are you suggesting that a tribal law is more foreign than the law of, say, Afghanistan?
No, Your Honor, but in the context of both Congress's support of the development of tribal courts and this court's recognition that tribal courts represent an essential element in tribal sovereignty and tribal self-government, it's important in this case to recognize that the tribal court is developing its own law in a case of first impression. It is taking what is essentially oral tradition and distilling it into what is essentially tribal common law to apply to the facts of this case. Because this court recognized...
You made a good argument for the tribe to have a certification procedure so a state or federal court might ask the tribe to clarify a point of tribal law. But to suggest that this is an exclusive, can you give outside the realm of the case you're arguing any situation where a tort claim is not transitory, where it can be brought in only one forum?
No, Your Honor. In this case, because we're dealing with courts of limited jurisdiction, tribal courts, as petitioner recognizes, and this cause of action only arises under tribal customary law, no other forum, no other state recognizes the underlying tort in this case. It represents a unique case in that sense. Therefore, only the tribal forum is available to vindicate rights under this tribal customary law.
But then isn't petitioner right that this is a gross violation of equal protection?
No, Your Honor.
That if it had been the law of any state of the Union, the petitioner could be heard?
No, Your Honor. As petitioner knows full well, the estate cannot bring an equal protection challenge in state court or federal court to the application of Public Law 280, because this court's holding in United States v. Antelope and Morton v. Mancari expressly, those two opinions expressly hold that federal statutes cannot be challenged by Indians on the basis of the Equal Protection Clause because Indians belong to a political class that do not come within the ambit of that clause. Furthermore, as this court held in Fisher, in particular cases, inherent tribal sovereignty will deprive an Indian plaintiff of a forum, of the state court forum. But because the Indian plaintiff is a member of a political group, the tribe, that will derive the benefit by protecting inherent tribal sovereignty, it is in the best interest of protecting tribal sovereignty to deprive that Indian plaintiff. Therefore, Your Honor, there is no equal protection challenge to Public Law 280 or inherent tribal sovereignty. In effect, the tribal court is the only game in town And the tribal court has a strong interest in adjudicating this case. Furthermore, a denial of jurisdiction in this case would breach the Treaty of 1877. This represents yet another interest that
But
the
so
tribe...
you are making this just special to this case, and you can't give me another instance of a jurisdiction monopolizing a tort claim and saying, this is our law, and we apply it in our courts, and nobody else can apply it.
I simply don't have an example for you, Your Honor, where there would be a similar non-transitory tort claim. Because of the operation of this jurisdictional statute, Public Law 280, all the other jurisdictions which petitioner allege are available simply aren't available, and therefore this claim can only be brought in the tribal court.
Does this tort exist only in this particular tribal area, nowhere else in the world?
Your Honor, I'm not aware of any other jurisdiction outside of this country that recognizes this tort claim, but certainly within the United States, there is no other jurisdiction which recognizes a descendable right to a name for 117 years. Only the tribal customary law, the Rosebud Sioux Reservation.
Isn't that an argument, a fairness argument, not to subject a non-Indian to a jurisdiction that recognizes a cause of action that doesn't apparently exist anywhere else on the face of the earth?
It doesn't, Your Honor, because the beer company deliberately affiliated itself with the tribal form by misappropriating Crazy Horse's name and exploiting his name for commercial profit. And it did so knowing...
Well, you would concede that at least until it received the letter, that there couldn't possibly be any liability, because it would have no reason to know of such an unusual law.
As my co-counsel recognizes, we simply do not rely on constructive knowledge here because there is actual knowledge. That letter represented the actual knowledge that the beer company had of the injuries it was causing in the tribal form, and yet it chose to deliberately affiliate itself with the form. It continued with its corporate strategy, knowing full well that it was causing harm on the reservation. Therefore, it cannot be heard today to argue that because this is a unique right under tribal customary law, it should be able to avoid jurisdiction in the tribal court. Furthermore, as this court has recognized, interests of efficiency weigh into the reasonableness considerations. And in this case, because the majority of the witnesses are likely to have been on the reservation, because this involves unique tribal rights, and tribal elders would have testified to those rights, and the estate itself would have given testimony as to the underlying harm here in this case. That efficiency consideration weighs in favor of the tribal court's exercise of jurisdiction.
To what extent does your reasonableness argument turn on the inability to bring this cause of action anywhere else?
Your Honor,
if, for example, we were to find that a state court could entertain this cause of action, what does that do to the rest of your reasonableness argument?
They remain intact, Your Honor. Certainly, we consider this a strong interest that the plaintiff in the tribal court had, the estate had, because it was the only form available. But as this court has recognized in National Farmers and Iowa Mutual, tribal courts are the courts best able to apply tribal customary law. And it should be a reasonableness consideration in this context that a state court or a federal court hearing this case would not be as able to apply tribal customary law and therefore provide the estate with convenient and effective relief, one of the considerations enumerated in Burger King.
How do we balance the due process rights of the beer company here?
Your Honor, in any personal jurisdiction analysis, the reasonableness considerations come into play to determine whether or not the burden on the defendant of litigating in the foreign forum is justified in light of these other considerations. In this case, however, we're dealing with a national corporation which sells malt liquor in 40 states, in states which have high Indian populations, and sells its beer also in the state of Ames, where the Rosebud Sioux Reservation is located. It has deliberately affiliated itself with the forum in order to profit commercially. In light of that, the consideration of the beer company's conduct against these other considerations, such as the lack of an alternative forum and the tribe's interest in self-government and protecting treaty rights it won against the United States, the burden, any possible burden on the beer company of litigating this case is simply...
Mr. Malice, it isn't the tribes, isn't the Bottomless beer company's real claim not so much the inconvenience of showing up in a particular court in Ames, but that that court will apply a law which is totally strange to it, and no other court, as you said, no other court would apply such a law. Shouldn't that enter into the balance of the appropriateness of exercising jurisdiction over bottomless beer? That the law that will apply is a very strange law to that corporation.
It shouldn't, Your Honor, because of the concession that the beer company made before this court tonight. Petitioner recognizes that saving the question of subject matter jurisdiction, under conflict of law principles, at least Maryland would apply tribal law. And as petitioner conceded tonight, it would be happy to have this case heard in another form, not the tribal form. So petitioner clearly is not concerned about the application of tribal customary law. It simply does not want to face the jurisdiction of the tribal court, because it knows if this court denies the tribal court's jurisdiction, it simply is judgment proof for the harms it caused to the estate.
But
So-
how does that, I sense a tautology here. How does that square with your argument that there's no other place it could be, this cause of action could be heard?
Your Honor, we argue that no other court has subject matter jurisdiction because of Public Law 280 and inherent tribal sovereignty. Petitioner, however, goes further and looks to the conflict of laws principles which would govern this case in another form, and recognizes that another form, such as Maryland, given subject matter jurisdiction, would apply tribal law. And petitioner further argues
Might apply.
might apply tribal law. In petitioner's brief, Your Honor, it recognizes that Maryland would apply tribal law under the lex loci delicti rule, Your Honor. But petitioner goes further and says it would be happy to have another forum hear this case. Petitioner knows full well that no other forum can hear this case. It's not a question of tribal customary law that concerns petitioner, but rather being judgment proof. And as this court recognized in McGee, personal jurisdiction analysis can't serve to make a foreign corporation judgment proof for the harms that it causes within the forum.
If you're wrong about the exclusivity of this forum, do you win or do you lose?
Your Honor,
if this is indeed a transitory claim.
we win anyway, Your Honor, because the tribe has a strong interest in adjudicating this case in order to fulfill its interest in preserving self-government and its own sovereignty. It must be able to develop its own law. By allowing a state court or a federal court to take this claim, as this court recognized in National Farmers, a tribal court's self-government, interest in self-government, can be weakened. Furthermore, the tribe has an interest in upholding treaty rights that it won against the United States in 1877. Article 8 of that treaty recognized that individual Sioux Indians would be protected in their property, person, and life. The tribe has a strong
If you
interest.
read that carefully, isn't it possible to argue that it was limited to real property?
Your Honor, there's no distinction made in the treaty between real property and intangible
What
property.
they were talking about farming, weren't they?
And
Occupying land.
That's correct, Your Honor. They were talking about farming and houses and other matters of real
Forms
property.
of real property.
However,
What personal property or property rights in a personal area were they talking about specifically?
I'm sorry, Your Honor.
What specific personal property rights were discussed in Article 8?
None, Your Honor. The word is simply property. And the tribal court has recognized the cause of action, which under tribal customary law, and has recognized that Indians have an interest in protecting the privacy and the property of the names of their forebears. That's an interest that the tribe has recognized by this very case. And in interpreting that clause, Article 8 of the Treaty of 1877, this court must follow the rules of interpretation which apply in the context of federal Indian law, which resolve any ambiguities in favor of the tribes. Therefore, absent any showing on the part of petitioner that clause can mean can have the distinction that it tries to read into it, the rule of interpretation favors an expansive view of what the tribes understood the word property to mean in the Treaty of 1877.
Thank you, Mr. Malice. Your time is expiring.
Thank you, Your Honor.
Is there rebuttal time? 3 minutes. Mr. Ryan?
Thank you very much, Your Honors. I would just like to briefly talk about why this is indeed a transitory action that the heirs may bring in a state court. Public Law 280 sets out in statutory form a list of 6 so-called mandatory states, and then allows other states through statutory means to opt in to that scheme. This court recognized in Fort Berthold 1 that there's a residuary state law jurisdictional basis that is not covered by PL 280, so that the reason that that case was even remanded back down to the North Dakota courts was so that they could inquire into whether there might be a state law jurisdictional basis. So it's clearly not the case that PL 280 covers the whole field and that there might be no other basis for a cause of action to be brought by an Indian against a non-Indian in state court. Then in the second case, when the case came back up, this court held that PL 280 preempted in only one direction. It was a jurisdiction-enhancing statute, such that the state could not disclaim jurisdiction that it should otherwise have. But there is no indication in the statute itself or in the case law of this or any other court that an Indian party may not sue a non-Indian in a state court.
Even if you're right, Mr. Ryan, isn't it that the most appropriate forum, it may not be the exclusive forum, but if you've got a claim of this nature, which is an unusual claim, why shouldn't it be heard in the forum that knows the most about it?
Well, first, Rosebud Sioux law has no adequate choice of law rules. They will always apply tribal law. Other states will do a choice of law inquiry and weigh which state's law should, the state that has the most interest. And that may lead to Rosebud Sioux tribal law, but there's certainly a right that we have
You
to
think
have
other states are detached and neutral in their approach to choice of law, as distinguished from the reservation, which has a homing instinct?
Heirs may bring suit in federal district court and have the federal district court apply the state's choice of law rules. I would hope that federal courts would be neutral.
A better brand of choice of law than Erie and Claxton would allow it? In the federal court?
That same Claxton against Stentor brand of choice of law inquiry would be done, and so long as that choice of law rule comports with due process.
Well, couldn't you argue that very principle before the tribal court?
No, Your Honor. Since the tribal court has a specific section of its code, section 4-2-8, which holds that whenever tribal law is on point, tribal law will automatically govern. And since the Constitution under Talton against Mays does not apply to tribal courts, we have no recourse under which to protest the inadequate choice of law rules of tribal courts. State and federal courts can hear witnesses about tribal law.
So you're saying it's just not fair for you to have to submit this controversy to the tribal courts?
That's right, Your Honor. Even if there were a minimum contact.
Yes.
What says you have to be fair?
This court's notions of traditional notions of fair play,
Due
substantial
process.
justice. The
And
due
I think your
process
time
notion
is up.
requires simply an equitable form.
Thank you.
Thank you, Your Honor.
Thank you very much.
Court will take a brief recess.
Following the argument in Pound Hall in the John Chipman Gray Room. It will be in honor of the judges, the Ames participants, and their guests. Thank you very much for your attendance.
seated, please. May I say first that for a bus driver's holiday, this evening's entertainment was a genuine treat, and you were all grand, and thank you. But good things must come to an end. And I have 3 announcements to make. The first is Best Oralist, and in this case, we agree that it's necessary to make a split decision. That is, we are unanimous that there are 2 Best Oralists, and they are David Campbell and Jonathan Malice. Next is Best Brief. The briefs in this case were of very high quality, but a prize must be made, and that prize goes to the John Marshall team, the petitioners. And interjecting that in real life, the brief has more staying power than the oral argument, we have determined that the best overall performer is the Marshall team. I know my colleagues have something that they would like to tell you, and I will call first on Judge Ervin.
Thank you very much. I would like to echo Justice Ginsburg's statement that I have thoroughly enjoyed being here, and I commend all of you for a splendid job. I thought the arguments were particularly good. They were substantially above the level that I often suffer through. And I think the one thing above all else that made all of your presentations good and impressive to me was the fact that without exception, you answered the questions that we put to you at the time we asked them, and you answered them generally, I thought, quite well. I did not hear one time I'll get to that in 5 minutes, or I'll discuss that in part 15 of my argument. Judges, when they ask questions, have an interest at that time, and if you wait or delay the opportunity to respond to it, you may well lose someone who, by the time you get to the subject, has gone on to something else. The best thing to do with questions, I think sometimes this sort of exercise may give questions a bad name. I would not deny, at least for myself, that there are occasions when we try to use questions as a means of making you make an admission that you don't want to make, or lead you down some primrose path which will end up in a trap at the end. And while that may sometimes be the case in this sort of enterprise, it is not the purpose of questions in the appellate courts that you will all hopefully have some opportunity to address. The purpose of a question is usually to indicate either that the judge has some question about some perhaps factual aspect of the case and is seeking to clear up something that is not clearly developed in either the briefs or the appendix or the record. On the other hand, and more likely, it signals to you some aspect of the case that that particular judge is worried about, some reason why he or she might not feel confident that your side ought to prevail. And so look on questions not as traps, as efforts to ensnare you in some untenable position, but as an opportunity to gain a convert, to point out to that judge why it is that the particular thing that is troubling the judge does not need trouble him or her, and why they should go ahead and decide in your favor despite that aspect of the case. I thought all of you answered the questions, as I said, quite well. And remember that questions give you a chance to convert someone to your cause, perhaps even to enable them to persuade some colleague to the judge's left or right, who the judge may think is not quite clear about this case yet. And perhaps with your answer to his question, the two of you might gain a vote for your side. So do as you did tonight, answer the questions directly, honestly, candidly, straightforwardly, and you'll do better than you will if you try to evade or dodge. If we throw you a softball, hit it back. It's amazing to me the number of times you can see a lawyer, you ask him a favorable question, and instead of agreeing with you immediately, you can see the wheels turn in his or her head, and they are thinking to themselves, what's the trick here? Where's the trap? And instead of hitting the ball back as you hoped he would do or she would do, they try to evade it. And that's not a good technique, and none of you did that, and I commend all four of you. That's more than enough from me.
Judge O'Scanlan.
Well, first of all, I want to thank Dean Clark and the Board of Student Advisors for inviting me to participate in this very distinguished panel, and I say that as the junior judge. It brings back some very fond memories because about this time of 1962, I was sitting in the audience, not as a participant, but just simply as an observer. And if anyone in that audience would have turned to me and said, what are the chances of your being on the bench at one of these in the future, I would have said 0 or less. So it's a matter of great personal joy to be here and to participate with Justice Ginsburg and Judge Ervin. I have to echo the sentiments of Judge Ervin with respect to my own experience on our circuit. The quality of advocacy here today, both in the briefs and in oral argument, would be among the best within our own regular routine of oral arguments. We sit on, we get something like 9,000 appeals a year in the Ninth Circuit. And I have to tell you that the quality of advocacy is very disappointing. When I came on the court, I was astounded to see that not everybody approached the Court of Appeals with the same respect in terms of preparation that was my own experience and the experience of my colleagues who would appear before the court. The training that you obviously have had here and the experience that you have incurred and the investment you've made in this effort, I hope will be something that you will return to the real appellate courts, state and federal, in your own practice. You have exceptionally strong talents in the appellate advocacy field, and I say as a favor to the appellate courts of this country, I hope some of you will find in your own careers that you will look to, if not an appellate practice specialty, at least the opportunity to assist us in appeals in our courts, because we desperately need, in my personal view, to increase the competence level of oral advocacy in the courts in this country. You have given us a great example, and I wish you all the best.
And now it's time to celebrate the winners. So the court will be in recess, and we'll join you at the reception.